There will be folks from the Equal Rights Center who will be monitoring the chat and hopefully able to answer your questions. And also, please stay on mute and off camera while you're listening, just because of bandwidth and just to not distract people. So I'm going to turn it over to Reginette Osby, who's going to give a really quick overview of the Arlington Landlord Partnership Program.
Okay, thanks, Jennifer. Good morning, everyone. As Jennifer said, I'm Reginette Osby, those of you who don't know who I am. As Jennifer said, I am one of the ALP co-chairs. Just wanted to provide a quick overview of the ALP for those who may not be aware of its existence. We are in our 10th year. This wonderful program was created in 2014 when a housing committee comprised of landlords and service providers discussed why homeless individuals and families could not secure housing. And the reasons identified were poor credit, poor rental history, and criminal backgrounds. So the goal of the ALP is to increase the availability of rental housing for homeless individuals and families. The ALP provides incentives to our landlord partners to lower their screening criteria, which has typically screened out many of our program participants. So program participants must be a part of the permanent, supportive, and rapid rehousing programs. They must be referred by their case manager and have been denied housing through the normal process by one of our landlord partners. We currently work with 4 landlord partners. Those are True Ground, formerly APA, AHC, Wesley Properties, and Paradigm. So that pretty much concludes my ALP briefing. If you have questions about the ALP, Jennifer's and my information is included in this presentation. And feel free to contact me for more details regarding the ALP program. And I'll turn it back over to Jennifer.
Regarding the ALP program. Thank you, Reginette. And I'll turn it back over to Jennifer. And we are recording. Wonderful. Thank you. So now it is my pleasure to turn the presentation over to Susie McClanahan, who is the Senior Project Manager for Fair Housing from the Equal Rights Center. And she, as I mentioned, will be going through her presentation, and do feel free to ask questions along the way in the chat. And we're really glad to have you here, Susie. So thank you.
Great. Just had to find the unmute button. Morning, everyone. I'm Susie McClanahan. I'm the Senior for Housing Rights Program Manager at the Equal Rights Center. Just as a quick check, can someone put in the chat or come off mute to say that they can see my PowerPoint in presentation mode? They're looking at the title slide.
Yes.
Yes. Perfect. Thank you so much, everyone. Okay. My colleague is also with us today. She can introduce herself in the chat, but Hallie will be monitoring the chat for questions. So please feel free to ask questions throughout. We'll get them answered in the chat, and if they require a longer answer, we'll also have a Q&A period at the end, but please don't feel like you have to hold your questions till the very end. So during today's training, we will work to recognize potential housing discrimination that renters may face, identify how renters are protected by federal, state, and local fair housing laws, and identify how to report potential housing discrimination. As a bit of background about the Equal Rights Center, we are a civil rights organization that identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in our home community of Greater Washington, D.C. and nationwide. As part of our work, we provide direct assistance to individuals who are alleging housing discrimination throughout the District of Columbia, Northern Virginia, including Arlington County, the state of Maryland, and Jefferson County, West Virginia. One of the primary ways that we seek to identify discrimination is through what we call civil rights testing. And that's where we have individuals pose as interested renters, for instance, and see what information they're giving.
Susan, I think you've got
Susie, you're muted.
Okay, great. I don't know how that happened. I haven't even been clicking. When did I mute? When did I get muted?
Just now.
Okay, great. Sorry, y'all. So I just went over the mission, and as I may have said or was muted during, civil rights testing is the primary tool we use to identify housing discrimination. And that involves having individuals, for instance, pose as interested renters, go to a property, and see what information they're given. So in the video, we have two testers, a white man and a black man, who go to a property. The white tester inquires of the agent that he's looking for a 1-bedroom unit and asks if any are available. And the agent says, yes, we do. Please get your application in soon. We then have a black tester come and speak to the property, asking essentially for the exact same thing. So he's also interested in a 1-bedroom unit and asks if there's any availability. In this case, the tester is told that actually they don't have any vacancies right now. And this is an example where an individual might not know that they're being given incorrect information, because it's really hard. Properties go really fast in Arlington County. Things might be on the market for only a couple hours, but sometimes it's harder to know exactly what's going on in more subtle forms of discrimination. So testing kind of helps us identify what those are. And I'm really happy to share that this year we had a testing contract actually with Arlington County. Where Arlington County had us we did about 65 tests of more than 50 housing providers throughout the county over the summer, and we were looking at kind of what does discriminate, is there discrimination in Arlington County, and if so, what does it look like? We did testing by both phone, email, and in person, and we did it based on multiple identities, including familial status, which is having children under the age of 18 in one's household, race, national origin, disability, and source of funds, which refers to how one pays their rent. And we frequently see source of funds discrimination towards folks with housing vouchers. So we've concluded our testing for this year. We hope to do testing in the future with Arlington County and would love to do it on an annual basis, because regular, consistent testing can help both identify and uncover discriminatory policies and practices. But it also gives us a better sense as to what's going on in the market, new trends, and provides an opportunity to address discrimination before any particular individual goes through it themselves. So now, just to give a bit of background, the Fair Housing Act is a federal law that was passed originally in 1968 that protects any individual nationwide from experiencing discrimination in housing. The law is quite broad, and while we traditionally think of it as applying to being in the rental market and that you can't, refuse to rent to someone based on a protected identity, it also applies to sales, lending, insurance. It applies to homeowners and associations and condominium associations. So it really applies to pretty much any kind of interaction in the sphere of housing. With that, it's illegal to discriminate nationwide based on 7 protected identities, and that is race, color, national origin, which refers to where a person or their ancestors are from, familial status, which refers to families with children under the age of 18, disability, religion, and sex. And the definition of sex in this case also includes gender identity and sexual orientation as well.
Susie, I don't think your slides are advancing. I'm sorry, there we go.
Okay, please chime in if there's further tech issues. So sorry. Are we looking at the additional protected classes slide now, Jennifer?
We are not. We're looking at the Fair Housing Act protected classes. So go forward one more.
Weird. Okay. I'm gonna sorry y'all, I'm not sure what's going on. So let me stop sharing and restart this because it's not progressing as I'm sharing it. Okay. Are we looking at the additional protected classes slide, Jennifer?
Yes.
Okay.
Additional.
Yes, we are.
Thanks. And please let me know if the slides continue to have issues. So there's 7 protected classes nationwide that we just went over, but there's also some additional protected identities both in the state of Virginia as well as Arlington County specifically. So in Virginia, it would be illegal across the state to discriminate against someone based on elderliness, which the law defines as being 55 years or older. Both Virginia and Arlington County also explicitly protect based on sexual orientation and gender identity and source of funds. And across the state of Virginia, they also protect based on military status. So folks who are in the military or veterans. Arlington County, in addition to protecting based on elderliness, sexual orientation, gender identity, and source of funds, also protects based on marital status. So for instance, we had a case where a landlord advertised that they wanted to rent to a husband and wife. And the individual that was interested in the property was a single mother. So that could be a sign of potential marital status discrimination because they did not want to rent to them based on the fact that they weren't married, as well as based on familial status in that case and their children, the number of children they had. But essentially, these are the identities upon which it would be illegal to discriminate against someone. So I want to talk now then about what is actually illegal to do. So I think the first and most obvious example is the refusal to sell or rent. But that's not actually always super clear. So one of the other things on here is misrepresenting availability, which was the example that we showed with the civil rights testing video. But it can also be, for instance, we had an Arlington County renter contact us several years ago because they had been interested in renting a unit and the landlord had texted the current tenant about like showings and thought that they were only texting the current tenant, but accidentally put the interested applicant in a group chat. And he said in the group thread, "I don't want to rent to her. She's African. Give her the wrong house number." And so in this case, he was trying to essentially engage in subterfuge to avoid renting to a woman that he made assumptions about her race and national origin. And she ended up, we helped her file a complaint with the Virginia Fair Housing Office, and she ultimately received a settlement of $20,000 based on that exchange because of how just harmful and disgusting it was. With that, it's also illegal to discriminate by advertising a discriminatory preference, like the example I gave with the ad that said, looking for a husband and wife with, a small family. That would be discriminatory advertising. Discriminatory terms and conditions refers to something like, for instance, enforcing rules differently based on someone's identity. So, for instance, saying that, families with children can't do X, Y, or Z at the property, but adults can. That might constitute discriminatory terms and conditions. Blockbusting doesn't really happen much anymore, so I'm not going to go into it today. But steering refers to when you push people either towards certain neighborhoods or towards certain properties. So for instance, if someone has a voucher and, property management says, "Oh, we don't take vouchers at this property, but here's some other ones you can apply to." That would be steering because you're directing people based on a protected class towards a certain direction. Additionally,
Susie,
it's
I'm
illegal.
sorry, the slides are still not advancing. We're still with additional protected classes. I'm sorry to interrupt. Do you want me to try to share so that you can kind of see what you're doing? I know it's hard to present and see at the same time.
Yeah, I'm not sure. It's got to be a Teams. Oh, okay. Sharing is paused. Why is it paused?
You're still sharing. Do you want me to try to share your presentation?
Yeah, that's fine. I'm not sure what's happening. I'm sorry all for the inconvenience.
Okay, can you all see my screen?
Yes.
Yep. So if you want to go to
Okay.
the next one.
I can figure out how to do that. Okay. Does that
Amazing.
work?
Thank you so much. Yep. Okay, so harassment, threats, intimidation, and coercion are also illegal. One of the kind of worst forms of this we see is sexual harassment in housing, which is absolutely illegal under fair housing laws. Inaccessible design refers to multifamily housing buildings that were built after 1991, and those must have a minimum level of accessibility in them, which kind of as a rule of thumb, someone who uses a manual wheelchair should be able to navigate the building. Retaliation for someone trying to advocate or enforce their fair housing rights is also legal, and any other conduct which would make units unavailable. Next slide. So we're going to be moving on to talking about source of funds discrimination specifically. This is an area where we see a lot of confusion and a lot of issues. You want to go to the next slide? So source of funds protections refers to any legal form of income. So that includes payments like a Section 8 voucher or housing choice voucher. It includes emergency rental assistance, disability benefits, Social Security income, alimony, pretty much any form of legal income that a person receives. It would be illegal to discriminate on that basis. And by far and large, the most common form of source of funds discrimination we see is towards folks who have housing vouchers or subsidies. So next slide. The most common examples of source of funds discrimination we see day to day is a refusal to accept vouchers at a property, discriminatory minimum income requirements, which I'll explain a bit more about in just a minute, direct advertising saying things like no Section 8, no vouchers accepted, they need not apply. And on the next, so those I would say that are the three most common. I don't actually think the video will play here this way. So if you want to, I think, skip the next slide, I think it's going to be a video. Yeah. So in the video that we can't see, I'm going to give us a general scenario. A woman goes to a property and discloses that she has a voucher. And the agent says, we accept vouchers here, but you must have a full-time job. We want to make sure that you have another form of income so that if you lose your voucher, you'll still be able to afford to live here. Can folks put in the chat whether they think that is legal, allowed, or whether that would be illegal in Arlington County for a landlord to do? What do folks think? Yes, great job for folks who are chiming in. Thanks so much. Yes, so that would be illegal because even though they said they accept vouchers, right, they're saying that they prefer or require a specific form of income, which is employment. So that would be a sign of housing discrimination. Now, an issue we see a lot of confusion about is regarding minimum income requirements. And when somebody has a housing voucher, their voucher is going to pay usually the majority of their rent. And so in that sort of instance, if a housing provider has a minimum income for a requirement, for example, like 3 times the monthly rent, they should make sure that they're only considering the portion of the rent that the voucher holder pays when determining whether that applicant would meet their minimum income requirement. So for instance, say rent is $2,000 a month. Sometimes housing providers will say, our minimum income requirement is $2,000 a month, so you need to prove that you make $6,000 a month. Your voucher is going to cover, $1,800. So 6,000 minus 1,800 is another $4,200 a month that you need to prove. And so they just subtract the voucher from the 3 times the entire rent, and then require that, the voucher holder to make a pretty large sum of money, which most of the time they aren't going to have because that's why they qualify for the voucher. That would be an example of a likely illegal minimum income requirement. What a landlord should say is, okay, our total rent is $2,000 a month, but your portion is only $200 a month in this example. So 200 times our minimum income requirement of 3 times the monthly rent is $600 a month. And so that would be an example of a legal or an acceptable minimum income requirement. So just know that this is an issue we see a lot of confusion about, and we have some resources in a minute that I'll share to that also help clarify this issue. Next slide. There are a couple of exceptions under Virginia's fair source of funds law. So a housing provider will be exempt if they do not own more than 4 rental units in Virginia. That being said, this implies for instance, we filed a complaint against a owner who owned 5 rental units as single family homes, but each of those homes counted towards this total. So it wasn't that if you only have a multifamily housing property with at least 5 units, it's 5, if you have at least 5 rental units across the state, you would fall under the source of funds requirements. And then the second issue is if a public housing authority or voucher administrator takes more than 15 days to review and approve a request for tenancy approval package, housing provider could essentially move on to another applicant. Next slide. The thing to note with the 15-day time frame, though, is that it starts when a complete package is submitted. So if a housing provider submits an incomplete request for tenancy approval package, they have to make the necessary edits, and only then, once they've submitted a complete, full, correct package, will that 15-day timeline start. Next slide. Okay, so as I mentioned, we have a couple resources for individuals who have housing vouchers, or for those who are assisting folks with vouchers. We have this FAQ sheet that explains common forms of housing discrimination and also discriminatory minimum income requirements. And if you go to this next slide, there's a guidance document actually by the state of Virginia that's quite detailed, a really helpful resource as well. So for housing providers or folks that are working with housing providers who may have questions about their responsibilities, we would really encourage sharing this document as well, because it explains source of funds within the state. Okay, next slide. So next, I want to talk about criminal record screenings. Next slide. There's kind of two major categories of concern when it comes to fair housing and criminal record screening. And the first is outright discrimination based on, for instance, like race or national origin. So we, several years ago, did an investigation called Unlocking Discrimination, where we looked at criminal record screening policies by DC and Virginia housing providers. And what we found is that sometimes the policies seem to be completely different based on the race of the tester. So this is a case where we had a Black woman tester go into a property and a white woman tester. They both disclosed a felony conviction on their record from 15 years ago. And to the Black woman, the agent said, yeah, they won't approve you. The white woman, however, was told a third party makes the decision and it depends on the type of crime and how long ago it was. These do not seem like the same policy, right? This seems like you're going to completely different buildings, even though this is the same building supposedly describing the same policy. So this would be a likely example of straight out race-based discrimination, where they're using and enforcing their criminal record screening policy differently based on the race of the individual who is disclosing something on their record. That being said, though, there's also the concern, if you want to go to the next slide, about more broadly the way that criminal record screening policies are going to impact renters of color. Because what we know is that the criminal legal system in the United States has both historically and currently targeted people of color for incarceration, meaning that people of color are much more likely to have criminal records, even though crime rates across race hold pretty much the same. And so any criminal record screening policy is going to disproportionately impact renters of color, even if race is never discussed. Next slide. So with that knowledge, in 2016, HUD, the U.S. Department of Housing and Urban Development, released guidance on criminal record screening policies. And what they said is that it would be illegal for a housing provider to consider arrest records, because the arrest records do not actually indicate whether somebody was convicted of a crime. It just means at some point in time, someone suspected them, but that ultimately, right, if they're not convicted, they were never found guilty of the crime. They also said that felony and conviction bans are too broad to serve like a meaningful non-discriminatory purpose, and that they are illegal as well. So for instance, we've had individuals contact us who said, I applied at this property, I have a felony on my record from 30 years ago, and I received an automatic denial notice because I had a felony. So that would also likely be illegal, because that's not actually an effective policy for addressing any sort of safety concerns. And third, it says that housing providers have to make an individualized assessment of a person's criminal record. And I will go a bit more into that in just a minute. So if you want to go to the next slide. So an example of a blanket ban policy would be, for instance, if someone was filling out an application and was asked, have you or anyone in your household ever been convicted? And in this case, there was a property that we alleged, essentially, if you put the answer yes, it would just block you from even submitting an application. And so that would be an example of what a blanket ban might look like. Next slide. So I mentioned that the HUD guidance requires an individual assessment of somebody with a criminal record. And what the guidance says is that specifically housing providers must, at minimum, consider what crime was committed by the applicant, when it occurred, how long it's been since the crime occurred. So the example I gave earlier of somebody being denied from a felony from 30 years ago, with that being the only thing on their record, right? That's likely not relevant to their current, their current tenancy and whether they would make a good tenant. The applicant's age when the crime occurred and any changes in the situation since. So for instance, we had a client who came to us and she, I think maybe like 8 to 10 years prior, had written a bad check. And she fully admitted that she had done that. And she explained that essentially it was a crime committed out of poverty. She couldn't afford groceries at the time. She was trying to take care of her kids and she made a bad decision. And so we helped her write a letter essentially explaining what happened. You know, in the letter she wrote how she fully took responsibility for what she did. She wrote about what the things that she had done in her community since then and, ways that she had tried to essentially change and, wrote about being like an active member of her church, volunteering, all that. And also wrote about why essentially she did this and how her economic situation had changed because she had a voucher now, meaning that she was able to secure safe housing for her family. And that had meaningfully changed her economic circumstances. So while she was initially automatically denied by the housing provider, when we contacted them and said that she was owed an individual assessment and provided this additional information, she successfully appealed the decision and they ultimately approved her. Next slide. Okay, so in an example, a person's application is denied due to a felony being on their record. The building says they don't allow anyone with felonies. Would this be allowed or would this be illegal? What do we think? Can a landlord do this? Yes, great job. So this would be illegal. This policy is overly broad and thus would likely constitute race and national origin discrimination under fair housing laws. Great. Okay, next slide. We also, for anyone who's working with an individual with a criminal record, we have a toolkit for them that talks through what their rights are. So when they're going through a criminal record screening and housing, that they will be better able to advocate for their rights, identify potential housing discrimination, and reach out to us if they need additional assistance. Next slide. Okay. Fair housing rights for folks with disabilities. We're going to talk a bit about reasonable accommodations. This is an area we also see a lot of questions come up at the ERC. I would say by far the highest volume of complaints that we receive from individuals throughout the region are based on folks who have housing vouchers experiencing discrimination based on their source of funds, or people with disabilities who are experiencing challenges navigating the process to request a reasonable accommodation. Next slide. So first off, I just want to take a step back and give a quick definition of disability in this context. So in the context of the Fair Housing Act, or the nation's kind of fair housing laws, disability is defined as a physical or mental impairment which substantially limits one or more major life activities. So for instance, if somebody uses a wheelchair, the major life activity that would be impacted is walking. If someone has PTSD, post-traumatic stress disorder, depending on the individual's symptoms, the major life activity that might be impacted is caring for oneself day to day. Sleeping might be impacted, especially if they, have nightmares or insomnia as it relates to that. So essentially the question always here, is there a life activity that's being impacted? And if so, then it may be a disability. The second definition is a record of having such an impairment. So for instance, the definition of disability might extend to someone who's in chemotherapy, has cancer, but is in remission currently. They might still need specific accommodations based on the fact that they're in recovery from cancer. And the third, which is less relevant for reasonable accommodations, is being regarded as having such an impairment. So just to give a quick example here, if somebody, for instance, was interested in housing, and let's say they're a wheelchair user, they go to the property and the manager makes an assumption that anyone who uses a wheelchair also has an intellectual disability and thus would be incapable of managing their own finances and living alone. That individual doesn't actually have an intellectual disability. The housing provider just made that up. And so in that case, they would still be protected by the definition of disability here because they're being treated as if they had one. But by far and large, the most important definition here is somebody with a physical or mental impairment that substantially limits one or more major life activities. So to give an example, do we think that asthma is a disability under this definition? Yes or no? Is asthma going to be considered a disability?
Yes.
Yes, why? What's the major life activity that's impacted? Yes, breathing, exactly. Great job, everyone. This can trip people up. So this is essentially if somebody, is sharing with you that they have a disability and you're not sure whether it qualifies here, that's kind of the thought process to go through. What's the disability? What are its symptoms? And is there a major life activity that's impacted? And if the answer is yes, then they are probably protected under the Fair Housing Act. So next slide. So reasonable accommodations are a change in rules, policies, practices, or services that give a person with a disability equal opportunity to use and enjoy a dwelling. And I know that's a bit in the weeds, but essentially what this means is that if a housing provider has a general policy or practice, say for instance, unreserved parking, parking is first come, first serve, but that policy or practice unfairly limits a person with a disability from access and enjoyment to their housing, then they need to modify that if possible for the individual with the disability. So in the case of parking that's first come, first serve, and for the individual with the disability, they should reserve a space for them if the individual requests it. That's closest to the entrance so that that individual always has parking available to them, but they can continue to provide first come, first serve parking to everyone else who hasn't requested a reasonable accommodation. So they don't need to change their policy or practice for everyone. They just need to make an exception or an adjustment for the person with a disability so that they have equal access. Next slide. So the most common examples that we help folks with when they're requesting reasonable accommodations is for folks to have emotional support animals in a building with a no pets policy, for folks to get a reserved accessible parking space that's closest to their housing, or for instance, a transfer to a more accessible unit. So say someone's living on the third floor, their disability symptoms are worsening, or maybe when they moved in, there just weren't any first floor apartments. But now they need a transfer to a first floor unit that's going to be more accessible for them. They have difficulty climbing stairs or walking long distances. Even if they're in the middle of their lease and the landlord doesn't usually allow transfers, they need to allow that person to move to a first floor unit as soon as one becomes available, and they get first right to those units. So for instance, there might be a wait list of other folks that are interested in first floor units, but a person with a disability should be given preference for that unit because they have a specific need for a unit on that floor. Next slide. Some other examples of reasonable accommodations that we've assisted people with are, for instance, an extension to a voucher. So if somebody has a housing voucher, they usually have several months to look for housing before they could potentially lose their voucher or the voucher expires. But if someone has a disability that makes it either difficult for them to access, for instance, they have a physical impairment that makes it difficult for them to see as many units, or it's more difficult for them to even find an accessible unit, for instance, you can request that they be given more time on their voucher so that they can find a unit that meets their needs. We had a client in Northern Virginia who had a mental health disability that caused her to experience significant levels of stress and depression. And so that made it more difficult for her to do her housing search in a timely manner. And so we got her an extension so that she felt like she had more time and thus could better look for housing without feeling under so much pressure and stress. You can also change the date of rent payment to match when a person receives disability income. So for instance, an individual is on Social Security disability each month and their payments don't come on the first of the month. You can actually ask that their rent payment date move to when they get their benefits so that they're paying they're paying the rent the day they receive their benefits. And we just talked about criminal records. In the case where somebody has a criminal conviction on their record directly related to a disability, you may be able to request a reasonable accommodation that not be considered. So for instance, say somebody 5 years ago committed property damage And at the time, they either had not received treatment for a mental health disability or were off treatment. And since then, either like in the past 2 years, they've been on treatment, their moods have stabilized, they haven't experienced any similar symptoms. We could say, look, as a reasonable accommodation, we're asking that you not consider this because they have addressed the underlying issue that resulted in that conviction. And the crime itself was a direct result of a disability. Next slide. So how does one make a reasonable accommodation request? So requests can be made verbally or in writing. They don't have to be made at any specific stage. For instance, an individual can make a reasonable accommodation request, when they're applying for housing. They can make a reasonable accommodation request when they've lived in that housing for 6 months. There's no proper or time limit on when they can submit their request. We do always recommend making requests in writing, although folks do have a right to submit them verbally if they want. But if there's any confusion as to what the request was or when it was made, having something in writing is very helpful. A housing provider can ask an individual to verify 2 things. So first, if their disability is not obvious or otherwise known to the housing provider can request verification of that. So for instance, somebody who uses a wheelchair, someone who's blind, deaf, those are considered obvious disabilities. You can't ask someone to verify those if you're housing providers. But if somebody has a mental health disability like PTSD, depression, there's no way for a housing provider to know that, and so they could request verification that the person has a disability. Second, if the relationship between the disability and the request being made is not obvious, they can request verification of that. So for instance, somebody who uses a wheelchair requests a reserved accessible parking space. They don't need to provide verification of their disability or their request because their disability is obvious and the relationship between their disability and their request is obvious, i.e. they can't walk very far. They need, they use a wheelchair. They need essentially a parking space as close to the entrance as possible. But if someone has an emotional support animal for PTSD, a housing provider does not know whether that particular person's symptoms related to PTSD are improved by having an emotional support animal. So in that case, a housing provider could request an individual provide verification of both their disability and the reason for needing an emotional support animal. That being said, housing providers cannot request information regarding the severity of one's diagnosis, the length of treatment, anything all they get to, essentially only the information they need is, does the person have a disability? What symptoms does it cause? And are those symptoms improved by the request being made? And I think we'll talk a bit later. Yeah, I'll go over a bit later about who can submit the request. So if we can go to the next slide. I do want to briefly talk about service and assistance animals because we get a lot of questions about these, both from renters and housing providers. So generally speaking, just as background information, service animals is a specific term that applies to dogs who are trained to provide specific tasks related to a person's disability. So this is like a guide dog for someone who is blind, or a hearing dog for someone who is deaf. They have specific training to perform disability-related tasks. This isn't like the dog is a good boy, he's well behaved. That's not disability-related tasks. I do have the word dogs asterisk because while I personally never have experienced this, technically miniature horses are also allowable as service animals, but 99% of service animals you interact with would be dogs. Now, assistance animals is a broader term. Service animals are allowed both in housing and public accommodations, so places of business. Assistance animals is a broader term only used for housing. And this can be any animal that's a service animal, or any other animal, whether it's a dog or not, that does work, performs tasks, or provides assistance to someone based on their disability, or just an animal that provides therapeutic support. So literally the presence of the animal alone is what improves the individual's disability symptoms. And so we usually call these an emotional support animal, comfort animal, or support animal. So in the housing context, any of these animals would be allowed. Next slide. If you're ever unsure whether an animal is a service animal or assistance animal specifically, can we go to the next slide? Great, thank you. If you're ever unclear, here's a quick flow chart for you. So, is the animal a dog? If no, it's never going to be a service animal unless it happens to be a miniature horse. So if the answer is no, you're talking about an assistance animal. If the answer is yes, then the next question is this dog trained? And again, not like, are they trained to be well behaved? Are they trained to perform specific disability related tasks? If yes, then you're probably talking about a service animal. If no, you're talking more broadly about an assistance animal. Next slide. The reason that this distinction matters is not, it's just that assistance animals overall are allowed in housing, but service animals are specifically allowed in both housing and places of business. So for instance, like restaurants, movie theaters, that sort of thing. And I see in the chat someone asked whether emergency homeless shelters are considered housing as it pertains to assistance animals. And the answer to this is that the term housing underneath fair housing laws pretty much applies to a place that someone has a right to return. So transitional housing programs are usually going to be considered housing. Emergency shelters that only provide shelter overnight and folks leave and it's like first come, first serve, again, the next day you don't have a right to return, are likely not going to be considered housing. But anything where you have a right to return, so even like an emergency shelter where once you get a bed, you can keep coming back and you'll have that bed for as long as you need it, would likely fall under the definition of housing. That being said, even if an emergency shelter that essentially doesn't have a right to return is going to fall under the ADA, the Americans with Disabilities Act, and people do have a right to request accommodations under the ADA as well. So either way, the information about reasonable accommodations is probably applicable to all of these settings. So that is the short answer. I know there can be more in the weeds questions, and if you have further, I'm happy to talk about that more in the Q&A period, but I just wanted to briefly answer that now. Okay, next slide. Okay, so when we talk about reasonable accommodations and emotional support and assistance animals, a lot of questions we get are regarding whose responsibility is it to do what. Housing providers are not allowed, when there's an assistance animal, to apply a no pet policy. They can't charge a pet fee or pet rent. So a lot of places now are charging like a $300 deposit for pets, or like, you know, $50 or something a month for pet rent each month if you have an animal. Those fees cannot be charged to a person with a disability if they have an assistance animal, because it's illegal to charge a fee for a reasonable accommodation. It would also be illegal to charge an additional security deposit or collect other fees to guard against potential property damage. We had a transitional housing program in Northern Virginia that tried to charge a tenant with a disability who had an emotional support animal a cleanup fee, because they said your emotional support animal is a puppy, they're going to ruin the unit, we're going to have to do like an intense cleaning after you move out, so we're just going to go ahead and start charging you this fee now. And we wrote a letter explaining that they can't actually preemptively charge a fee for damage they don't know whether or not it's going to happen. That would be discriminatory. And so they ended up removing the fee. Next slide. Housing providers also cannot require that an assistance animal be a certain breed. Some buildings like say we don't allow Rottweilers or pit bulls, things like that, and you can't apply a breed ban to an assistance animal. They can't require that the assistance animal be under a certain weight or size. So for instance, if you only allow pets that are under 25 pounds, that requirement would have to be waived for someone with a disability who has like a golden retriever as an assistance animal. The housing providers cannot require that animals show formal training or certification. And I do just want to put a quick asterisk here that there actually is no certifying agency in the United States for assistance animals. There's a lot of online registries that exist. All of them are essentially fraudulent. There is no like that provides you no level of protection. And so especially for folks who are working with people with disabilities, I've seen many of them come to our agency and say, hey, look, I have an emotional support animal. I registered it online. And while they do have an emotional support animal, that registry in no way impacts their rights. It does not help them in any way. So essentially those online companies are taking fees from people with disabilities, frequently do not have the additional income to kind of pay these costs, and kind of exploiting them. What, sorry?
Yes.
Do you have a comment? Okay. So just want to flag that online registries do not grant anyone any particular rights regarding their animal. And lastly, they cannot require that a assistance animal wear a harness or vest. Next slide. Okay, now the rights and responsibilities of the person with the disability who has the animal. Animals must follow the behavior outlined in standard pet policies, such as like leash rules, waste pickup, that sort of thing. With the exception that if an accommodation is necessary, that should also be granted. So for instance, we had a client who in Arlington who had in this case, she just had a pet, but she used a wheelchair and couldn't pick up after the animal. And so she had a reasonable accommodation from her housing provider that her husband would pick up the animal's waste within 24 hours, but that if she took the dog out while he wasn't home, building management would not fine her for not picking up after the dog because they knew that her husband would come back later and get it. So that's an example of an accommodation to the actual pet policies as well. Animals cannot pose a threat to other residents or property. Now, this threat determination must be based on the individual animal. It cannot be based on stereotyping of animals. So for instance, if someone has a pit bull, you can't say pit bulls are threats to other, like a landlord can't say pit bulls are threats to other people, the animal can't be here. But if an animal is like foaming at the mouth, trying to bite other residents, they can say this animal is, currently a threat to the safety of other residents. We can't allow the animal to be here. Now, if the individual does get that animal trained and the specific behavioral concerns addressed, the animal would have to be allowed to return to the property. Residents must pay for any damage caused by the animal, and the animal has to be up to date on vaccinations in accordance with state and local laws. Next slide. Okay, so who can verify a disability or need for an accommodation? We were talking earlier about how housing providers can request verification for two reasons. One, to verify whether a person has a disability, and two, the relationship between the request and the disability itself. And that disability verification can be by any third party who reliably knows about that individual's disability. So it can be a doctor or a medical professional, but it doesn't have to be. It could be someone's therapist. It could be like a caseworker or a social service provider if they know about that individual's disability. For instance, like somebody like a permanent supportive housing caseworker who's, only working with individuals who have like mental health disabilities would likely know then about their client's mental health disabilities and could write verification letters. A member of a peer support group like Alcoholics Anonymous or other forms of like disability support groups could actually write the letter on behalf of the individual, or any other reliable third party. And we actually have a verification template because one of the things we see is that when folks go and request these letters, frequently either they're not the housing or the third party verify is not either including sufficient information for the request to be approved by the housing provider, or they're including way too much personal information that they didn't have to disclose about that individual. So we have a template that folks can use that essentially outlines what information needs to be added so that people with disabilities can just take that to who they want to verify their disability and get that filled out. Next slide. So in a scenario, we have a wheelchair user request an accessible parking space. The landlord approves the request but says they don't have the money to pay for it. So the tenant has to pay for the curb cut and for the sign to be installed. So the curb cuts, if you see in the photo, the blue part that kind of forms the slight ramp from the parking space to the sidewalk, that's a curb cut. And usually there's a disability, a reserved parking sign up as well. Did this landlord correctly respond to the request? Did they handle this properly? What do we think? Let folks chime in on the chat. So In this case, the housing provider was correct in approving the request, but they actually flubbed when they said that they were going to charge a tenant for the curb cut and the sign. Housing providers cannot charge a person with a disability any sort of fee for implementing a reasonable accommodation request. So any sort of incidental cost for putting in the reasonable accommodation request would actually be at the cost of the landlord. So it's the landlord's responsibility to pay for the curb cut and the sign to be installed in this case, and they cannot tell the tenant they have to cover those costs. Okay, next slide. And another example, we have a renter with PTSD or post-traumatic stress disorder who has an emotional support dog. The landlord says they will allow the pet, but the tenant will need to pay the $300 pet fee, and the dog cannot weigh over 25 pounds. Do we think the landlord responded to this correctly? Okay, I'm seeing a lot of no's. Can anyone say why? No is the correct answer. What did the landlord do wrong? Yeah, great job, everyone. So they can't charge the pet fee, and they can't specify that the dog has to weigh less than 25 pounds. So the fee and the weight limit are the problem here. Great, next slide. Okay, last example. A tenant with depression has a cat as an emotional support animal. What information would they need to submit to the landlord for their cat to be approved as a reasonable accommodation? What do we think? So if the landlord requests vaccination records, they can go ahead and supply those, but they don't have to submit them from the get-go. But they would need to submit a letter from a therapist or someone, another reliable third party, that they have a disability and what symptoms of the disability is improved by the cat. So great job, everyone. And we're going to skip the next example. So if you want to go 2 slides ahead, that'd be great. Thanks. Okay. So we have some resources for folks with disabilities. I mentioned the verification template earlier. We also have a toolkit for folks about reasonable accommodations and modifications so they know their rights and how to make those requests. And because we get so many questions about assistance animals and service animals, we also have a 1-page graphic that explains what the difference is between them and where those animals are allowed. Next slide. We also have resources for housing providers. So we have an FAQ guide for the most common reasonable accommodation questions we get from housing providers. We also have a flow chart that housing providers can use when considering an emotional support animal and how to review that request. And we have a video for them as well that kind of talks through the flow chart. Next slide. Okay. So lastly, I want to talk about how one can report housing discrimination. Next slide. So if an individual experiences housing discrimination, they have a right to file a complaint. They can reach out to the ERC to learn what their rights are and kind of how to proceed based on what next steps they want to take. They could also file a complaint, and they can't file it at more than one place, but with HUD, the U.S. Department of Housing and Urban Development, the Virginia Fair Housing Office, or the Arlington County Office of Human Rights. So those options are also available to them. Next slide. For individuals who contact the ERC, there's several ways that we can assist them. So number one, we can provide advocacy with the housing provider to address possible discrimination. I mentioned earlier that there's a lot of confusion about minimum income requirements when it comes to folks with housing vouchers. So for instance, a common type of advocacy we do for folks with housing vouchers is when they report that they think their application was incorrectly denied based on a minimum income requirement, we write a letter to the landlord explaining how they should have run the minimum income requirement and asking that they rerun the individual's application. So that's just one example. We also assist people with disabilities with submitting reasonable accommodation and modification requests to housing providers. We will actually work with the individual to identify what specific information they need to include in a request, help them kind of get a sample template of that information so that they can provide it to whoever's going to do the verification. And then we will take that information and submit the request directly to the housing provider and make sure that both the request is approved and also that it's then fully implemented correctly. Next slide. Beyond that, we also assist people with submitting housing discrimination complaints with the Virginia Fair Housing Office, or HUD, and we serve as that person's representative or advocate. I talked about an individual in Arlington who had wanted to apply to a home and got a nasty text message from the landlord saying that he didn't want to rent to her based on her race and national origin. In that case, we actually helped her file a complaint with the Virginia Fair Housing Office. And we went through the entire complaint process with her, put together her evidence packet and everything so that the process would be as smooth and easy for her as possible. And ultimately, she was able to reach a settlement agreement with that landlord. We do civil rights testing. We, for instance, do testing both on like behalf of, for instance, Arlington County so that they understand kind of what's going on in the local market. We also do kind of our own larger testing projects to better understand what's happening in the housing market, but we also do testing actually directly for individuals if it might benefit kind of what their allegations are. So we had a case where somebody with a voucher contacted us because, you know, she went and did a tour. When she disclosed she had a voucher, the landlord correctly said that they would take vouchers, but she said his entire demeanor changed after that happened, and he just seemed really unhappy to learn that she had a voucher. After the tour, he called her soon after and said that they'd actually had a really strong application in on that unit, but he was willing to show her other units in a different part of the area. And she called us and said, look, I don't know if this is discrimination, but like my gut is telling me it is. And the whole interaction just felt really weird. And what we found when we did testing is that if a person with a voucher contacted that agent, they were told, oh, it's actually already been rented. But if somebody without a voucher contacted that agent, they were told, actually, we have multiple units in that building available. So we were able to help substantiate what had happened via testing evidence to prove that actually what they were saying to her wasn't true and was a subterfuge in order to avoid renting her based on her voucher. We were able to use that information to help her file a housing discrimination complaint. For individuals with disabilities, we can do accessibility site surveys at multifamily housing that was built after 1991. So if there's inaccessible features in that building that are not in alignment with the accessible design construction requirements, we can then contact the property and ask that they make those changes in order to, like at their own cost for the individual. So the number one issues we see here are improperly designed parking spaces and also too heavy door pressure that folks like can't actually open doors. But individuals don't have to know what the violation is. We can come and just tour the property and check for concerns that they have. It's very niche in the weeds kind of requirements. Next slide. Okay, so what can you do? So for folks who are service providers on this call that work with renters, it is really helpful to document your client's experience if they're reporting potential housing discrimination. The date and time it occurred, who the individual spoke to or they contacted, you know, if they know the name or at least like their job title, that's really helpful. A summary of what happened, and if there's anything that was submitted in writing, we really recommend keeping copies. So if someone submitted a reasonable accommodation request on a handwritten letter, they should, if it's possible, they should keep a copy of that letter or take a screenshot with their phone before they submit it to management. Next slide. For individuals who want to file a complaint with the ERC, I know my coworker Hallie put her information in the chat earlier, but folks can reach out to us by phone or email. And folks can also give Hallie a call or email directly as well. And I see someone with their hand up, and I promise, like, we're literally one slide away from being done, so I'll answer your question then. Next slide. Great, and this is the question slide. Okay, thanks everyone for attending today. I'm gonna have a Q&A period now for questions. And I believe Arlington County is gonna be distributing a survey either in the chat or later today as well for folks that we'd love for people to fill out. So before I turn it over to questions, is there anything, Jennifer, you wanted to add?
No, thank you. That was really helpful. And I think there were a few questions in the chat. Some of them may have been Arlington specific. So if DHS or other folks want to jump in to answer those too, that'd probably be helpful. But looks like we have a couple of hands up.
Okay, so we'll do the hands and then I'll go look at and then we can do questions in the chat that didn't get answered. So first hand up. DA score.
Susan, can you hear us?
Yep.
So I don't know if I missed this, but so if you have a tenant that was approved to have a guide dog or the assistance or the emotional support dog, and that animal bites another tenant, who's responsible for that?
So the housing provider can essentially require, if a reasonable accommodation poses a direct threat to the safety of other residents of the property, the reasonable accommodation doesn't need to be granted. So if somebody has an emotional support animal that is a direct threat to the property, the animal does not have to be allowed. Although if the behavioral issues can be corrected, then the animal would be required to be allowed once those issues are corrected. But questions as to who is liable for an incident, I would recommend talking with an attorney about like what your lease, like what a lease says, and those sorts of questions. So that's a partial answer to your question. Do you have other questions or anything further on that?
No, that's fine.
Okay. Anne?
Hi, can you hear me?
Yes.
Hi. My question is, if a tenant is receiving the Arlington County Housing Grant, not the voucher, is is the landlord allowed to ask that you have it sent to the headquarters in another state rather than just submit the check to their leasing office?
Okay, so in this case, somebody receives a subsidy and the landlord is requesting that subsidy payments go to a different office and not to the leasing office. Is that right?
Yes, and it would, part of it too also is the timing of getting it to mailing it then certified. It would most likely end up late.
I would be interested in specifically what's going on here. This sounds like an example that might be based on a current situation. If a housing provider has different terms and conditions for folks with housing vouchers and other residents. So for instance, they'll accept checks from any other resident for rent at their leasing office and are only requiring subsidy payments be made to headquarters. That might constitute a discriminatory term and condition under Virginia's Fair Housing Law and source of funds. So I would recommend actually reaching out to Hallie, and she can, I think, put her contact information in the chat again about this specific scenario and like what your concerns are.
Thank you. Can I ask one other question quickly? I'm sorry. Also, the other thing, when there are mice in an apartment unit leasing and they are having, I reported it over a month and a half ago, and I have been having to pay my rent, and I'm still not, they're refusing to transfer me to another apartment unit, but allowing me to leave if I want. But that's not an easy circumstance, receiving a housing grant, being on disability.
So the question is the concern that essentially you're trying to get a unit transfer due to housing conditions and they're letting you break the lease, but they're not letting you transfer. Is that right?
They say I can break my lease, but they will not transfer me. And they have 3 high rises. And I've experienced this before. And last time they would allow me to transfer to another unit. And this time the management is saying no. And I still, there's mice and there's in the unit I'm living
There's
in.
a couple parts to this question. Generally speaking, fair housing laws are not going to be helpful in the case of housing conditions. Those sorts of concerns are going to fall under like the landlord tenant laws of a state or county. So generally speaking, there's not much that like we can do when folks contact us about housing conditions because it's not a fair housing issue. That being said, if someone has a disability that's being worsened by a housing condition, that might mean that they then are entitled to a reasonable accommodation. So we've had cases, for instance, where individuals with disabilities, particularly respiratory related disabilities like asthma and allergies, those conditions are being worsened by the presence of mold or mice or other pests. And we've requested either like that they be prioritized for remediation, that they be prioritized for pest control, or that they be able to transfer to another unit if there are other units at the property without these issues. So that's possible that it could be a reasonable accommodation request if there's a disability relationship there. Then separately, there's the question of even if you have a reasonable accommodation request for a unit transfer, whether or not they can transfer people between buildings is going to partially depend on whether, like, what the ownership structure of buildings are. So for instance, there's some management companies that manage a bunch of buildings throughout a region, but they're all owned by different entities, and those owners set different criteria and whatnot for buildings. So a management company couldn't say somebody living at this building over here can just unit transfer to another building we manage, because they're not necessarily the owner. But if a building is being managed and owned by the same entity, and they own and manage other buildings, then it is possible that they could transfer between buildings. Or if, for instance, there's like a larger site that operates like 5 buildings next to each other and they're all owned and managed by the same one, then it would be possible to transfer between units, between buildings. So it just depends.
Thank
Does
you.
that answer your question?
Yeah, somewhat. I mean, it's just having mice in my apartment unit. It's not healthy for my situation, and I'm still having to pay my rent. And
I would also really recommend contacting like the local legal aids for assistance on that, because housing condition issues are serious. They're just outside my area of expertise.
Thank you.
Yeah, thanks so much.
If I
before we
could
go
just jump in, I'm sorry. Another option is to call code enforcement, and I will put that number in the chat because they really can handle building conditions, including pest issues. So I'll put that in and give them a call as well if you haven't.
Great. Okay, before we answer other hands up, I'm going to quickly go through some of the questions in the chat from earlier. So Mark had asked, what were the results of the testing, and is that public knowledge regarding violators? So the testing, the results of the testing have been provided to Arlington County, or the ERC is currently doing so. What Arlington County does with that information, I can't say, so that would be a question essentially for the county, although I don't think the county's manager office is the one who is overseeing that contract. Someone asked if we can get copies of the FAQ sheets, and I can send out those links. I'll send them to Jennifer after this so that she can circulate those as well, along with my contact information. Mark, if you want to go ahead with your question.
Hi, thanks. If somebody has a voucher and their lease is up and can the landlord raise the rent more than the voucher amount could cover?
So if someone has a housing voucher and the landlord decides to raise the rent, if they're raising the rent in order to avoid renting to the voucher holder, for example, like they're not raising the rent either at all or at the same level that they are for renters without vouchers in the building, that would likely be source of funds discrimination. But if they're raising rent for all kind of tenants of the building, regardless of whether they have vouchers at a similar level, and the consequence of that is simply in the case of somebody with a voucher that the rent's no longer considered reasonable or it's outside the voucher amount, unfortunately, there's not going to be really anything that can be done about that. So it depends on the motivation behind the rent raise.
Thanks.
Other questions? Someone asked, can you require the resident to have pet insurance? So it's illegal for folks making reasonable accommodation requests to be charged a fee in relationship to that request. So generally speaking, requiring pet insurance would be an additional fee and barrier to approving the request. So that would likely be considered a discriminatory and illegal barrier. Oh, and it looks like Hallie answered that in the chat already. Sorry, y'all. Okay, Olivia. Olivia, if you want to come off mute.
Looks like she might be having issues with her microphone. Olivia, if you want to put your question in the chat, that might work.
Well, we're waiting for them. Are there any other questions?
Mark had asked earlier too, what were the results of the testing, and is that knowledge regarding violators?
Yeah, so essentially we are turning over the results of the testing to Arlington County, but it's up to Arlington County to decide whether to what if any information they want to publicly release about the testing results.
And I did check with the Office of Human Rights because I knew this question would come up, and the testing results will be published. I imagine anonymized. They won't have individuals or properties, but they will publish sort of the general results.
Great. Any other questions? Jennifer, if you want to close this out, then.
I will, and thank you so much, Susie and Haley. That was really helpful and interesting and lots of good information. So thanks everybody for participating. I believe Daniele is putting an evaluation in the chat. So if you can let us know, looks like she did with a QR code. So let us know if this was helpful for you, if you know, anything like this that would be helpful in the future. We have a slide that has my information, Reg Jeanette's, and also Susie's. And as a reminder, if you put your name and email in the chat, we will forward the presentations and recording to you. So I think that is it. So thank you so much, Susie and ERC staff, for coming. That was really helpful.
Thank you, Susie.
Yeah, and thanks so much, Arlington County, and the work that your office did to make this happen. Really appreciate it.
Our pleasure. Have a great day, everybody.
And please fill out the survey. Thank you.
Thank you.
Thank you so much.